Hello, everyone. We're going to go ahead and get started. If you all don't mind just taking a seat. I know everybody's still finishing their lunch, so they can mosey in when they need to. Good afternoon, I guess, since it's now 12:30. My name is Tara Weilbacher, and I am on the board of directors of the organization ACCDFW. I want to acknowledge our sponsors for this session. This is GreenbergTrauig, and we are very grateful for them. They have continually supported our chapter for quite some time, and we just really appreciate working with them. Today, you're in the transactional space, and we're going to be talking about intellectual property value and joint ventures. And to my left, I have a couple of folks I want to introduce. We have Jerry Fellows, and Jerry practices in the intellectual property space, which includes enforcement strategies and enforcement rights, both domestically and foreign patent rights as well. And next to him is Steve Bartz. Steve is the JV expert. He focuses his practice on transactions involving sophisticated joint ventures, strategic alliances, and M&A. So I will turn it over to both of you, and thank you.
Thank you. So welcome, everybody. Thanks for showing up. Obviously, we are not going to be offering ethics credit in connection with this. That's the presentation next door. So I presume that you all are ethical, so we don't need to hit that portion of the presentation. So let's see. I guess should we flip through here? We'll give you the obligatory advertisement for the law firm. Yep, it's a firm. We don't practice out of our garage, but there actually is some pretty interesting information on that, so worth checking out. So let me give you an overview, but actually before I jump into that, just before I give you that roadmap, just like to ask a few questions of you all. So out of curiosity, how many of you are planning to execute on an external growth strategy in 2022? Got a couple? And how many of you have worked on joint ventures or are currently working on a joint venture for your organization? All right, good deal. Of those, how many had a good experience in connection with that? Okay, fewer hands. All right. Well, we'll see if we can't maybe give a few tips that will make that process a little bit better. I can't necessarily promise it'll be easier, but hopefully it'll be a little smoother, a little bit more productive and more value added in the end. So here's our roadmap for today. We want to talk a little bit about IP as a valuable asset and recognizing that. Want to also discuss recognizing that there is in fact value to protect. Oftentimes, we'll come across clients who maybe don't have a huge portfolio, maybe there's nothing filed, but that doesn't necessarily mean there's nothing there. We'll talk a little bit about how to enter into the joint venture, how to pair up without squandering value, and then we'll talk a little bit about how to retain that value, and we'll also leave you with a few parting thoughts. So. See if we can't get this to move. There we go. All right. So appreciating IP value. When you take a look at your company, when you take a look at your organization, it doesn't matter what industry you're in. These days, intellectual property, technology, IT, these are the drivers of the new economy, if you will, right? The macroeconomic situation is one where these things are becoming more valuable year over year. And as a result, it's paramount to protect that intellectual property whenever you're partnering up with a third party. So on the valuation side, what does that look like? Well, an important thing to recognize is that JV valuation looks a lot like M&A, but it's not exactly the same, and quite frankly, it's more difficult. So when you're looking at doing an M&A deal, a traditional M&A deal, what you do is you value some existing business, or you determine the worth of specific contributions that have some sort of associated revenues or income streams, and then you have industry comparables to provide some sort of benchmark to the valuation range that you come up with. Then you work through certain assumptions about the growth prospects, synergies, liabilities, risks, and then methodologically, the valuation process that you have laid out for you is pretty well mapped. And there's a pretty well-established set of valuation techniques that you can utilize and from which you can pick. Usually with M&A transactions, the work stops there. JVs, however, add several different layers of complexity to it. So companies may plan to contribute to the JV certain existing businesses, product lines, assets, cash, future capital commitments that may lend themselves, or excuse me, that do not necessarily lend themselves to a traditional valuation. They might, but they might not. But those contributions, even if they can fit into the traditional valuation techniques, those contributions are rarely the full list of contributions that go into the JV. And thus, that list is rarely what actually drives the final valuation, the final ownership split, and the economic arrangements in the entity. So most JVs include a range of important contributions that are not bundled into an easy-to-value business with existing cash flows. They're often like hard-to-value pieces of a business. Examples: market relationships, capabilities, technologies, proprietary data and processes, skilled people, support services, and other privileged assets that do not have an external market value or a market price. So, unlike M&A, the ownership of many of these contributions also isn't transferred to the venture. Sometimes, instead, it's provided by one partner to the joint venture under some sort of exclusive or under a privileged basis. There are also relatively few situations that lend themselves to an auction process, whereby essentially in negotiating with multiple parties, you can create a market to value something that otherwise wouldn't exist. So that's another difficulty in connection with valuations in the JV process. So, a little bit of blocking and tackling, kind of setting the table for when we dive into the meat and potatoes of this. So, businesses have a certain set of ways that they can grow, right, to pursue external growth strategies. And then, flipping forward one, on the external growth strategy side, you've got a few things that come to mind. So there's the heightened importance of IP protection whenever you're pursuing an external growth strategy. And there are particularly magnified consequences of failing to protect the IP. So the three different flavors of external growth tend to be M&A, franchises, and then joint ventures and strategic alliances. One thing I'll note is that when I refer to joint ventures, generally speaking, I'm referring to relationships that are structured as joint venture companies, but strategic alliances can also exist, and the distinction I would draw there is that effectively a strategic alliance is a joint venture that is done independently through contracts alone rather than utilizing a separate joint venture company. So, what are the benefits of pursuing a joint venture strategy? Well, three main flavors: access, risk mitigation, and gaining scale, right? So you want to figure out, are you doing a scope deal, are you doing a scale deal, or are you trying to mitigate risk? And so on the strategic side, several different flavors, right? Access, are you trying to get access to combine or co-develop capabilities? Are you trying to access new or different products and services? Are you trying to access new markets? In connection with accessing new markets, oftentimes you have to worry about regulatory requirements. So oftentimes when you enter into a foreign jurisdiction, there are certain requirements regarding what percentage of ownership the local partner has to have. And then on the financial side, there are a variety of other different rationales for entering into those types of joint ventures. Risk mitigation is pretty straightforward, and of course scale, you're just basically looking to grow the size in order to realize economies of scale. So, difficulties. Freedom and flexibility. As noted, it's a double-edged sword. Virtually every LLC partnership statute that's out there is drafted as an enabling statute, right? Where you've got certain default provisions, but you can otherwise modify those. They do not provide the level of detail that most of the corporate statutes provide. What that means is that it's great from the standpoint that you are able to customize your joint venture utilizing alternative entities frequently in a way that you can't use in corporations. The flip side to it is that there's also a corresponding responsibility that goes along with that. You can't just rely on default settings. So what it can mean is that it can be as simple or as complex as you want to make it. Another issue, heavily front-loaded, right? On the joint venture side, you have to not only think about the acquisition, if you will, or the pairing up, but you also very much need to think about the exit. Kind of like buying real estate, right? They say always think about the sale when you're making the purchase. Then I'll hit the last two as well here. So the common misperception of LLCs, for example, is simple and easy. I run into this with a fair amount of frequency where folks will say, oh yeah, it's a joint venture. We do those all the time. How hard can it be, right? It's not a big deal. And so immediately there is a mindset that this is going to be something that's kind of an afterthought and is simple. On the flip side of that is oftentimes folks who have sort of been through the trenches before, specifically in doing complex strategic joint ventures, is that it can be really tricky to do well. And as a result, sometimes the folks who recognize the difficulty involved will look for shortcuts. And we'll talk a little bit more about those later. But yeah, it's sort of an interesting thing where you've got potentially competing ways that a joint venture will be viewed, even within the organization. You, for example, may understand the complexity associated with it and want to really ramp up for that. But perhaps your board or CEO may look at it and say, oh, this is going to be simple. And so right from the get-go, there could be a potential disconnect in terms of what the process may look like. So, ways to grow. Joint ventures. Because of the confluence between and among the constituents, a very high confluence, protecting your IP in these scenarios can be very, very difficult. And it's something where you need to get an IP expert involved probably at a very early stage to think through the various angles. Because one of the elements of a joint venture is that it needs to be something where it's relatively easy to move things into it, but also to divide and return them, right? There's a certain fluidity to it. And so that needs to be not only recognized on the front end, but you also need to address the related issues to that when you start entering into the documentation. At the end of the day, it's not really a science, it's more of an art form. So, the two main issues that we see, already kind of touched upon a bit. One instance where the parties sort of fail to recognize the multiplicity of issues associated with JVs. The other is where the parties fully recognize and appreciate it and then try to shrink back from the task of working through those issues, looking for a shortcut or a politically expedient solution. One of the ones that we see oftentimes in connection with IP will be something along the lines of, let's just jointly own the IP. Major problem. We'll dive into that in a little bit, but that is a shortcut that should immediately sort of get your spidey sense tingling a bit and should probably be avoided.
So, hand over to you.
Sure.
So we're talking about the relative contributions of the two parties, and oftentimes there's a disconnect. Part of the time that disconnect, oftentimes the disconnect is because IP attorneys, patent attorneys in particular, oftentimes are not good communicators. Patent attorneys have to have a hard science or engineering background, and you don't generally go to those folks for the best communication skills. Probably enough said there, right?
Present company excluded.
Oh, you're very, very kind. Even me. So as you'll see, so that it can lead to a disconnect. Additionally, a lot of attorneys hate conflict for whatever reason. Not that we like conflict, but there are times when conflict is necessary to achieve your client's goals, and you need to have that as part of your range of capabilities. And so, in negotiations for intellectual property protection, if you hate conflict, you're not going to negotiate hard, and therefore the value of the intellectual property is going to be less. Oftentimes, clients do not understand that. Partly because the patent attorney is not communicating that. There's just not that good. You have a lack of communication skills, and then also you have just not the greatest communication path between the client and the patent attorney or other IP attorney with respect to really what has taken place in the negotiations or lack thereof. So when you're going into these discussions, you want to have your IP expert, if it's IP heavy at all, and oftentimes you'll want just a quick evaluation as to whether or not that's going to be the case, and that can change based on your due diligence. It could be you might think it's IP heavy to start, and it may ultimately end up not being that. Recently had a $5 billion deal where thought it was going to be pretty IP heavy, and it turned out that the patent coverage really was not what was anticipated. So give the benefit of the doubt to your colleagues, your business colleagues on the other side. And we got ways to cut through that lack of the lack of communication, effective communication with respect to value.
And I think an important element of that, at the outset, one of the items at the top of your checklist should be to have a discussion with your IP expert about what value is there, but to just don't make it a static conversation. It needs to, in the context of JVs, you should always think of it as a dynamic situation. So in the context of M&A, one of the key differentiators is if you're doing an acquisition, you're doing a merger, it's basically a snapshot, right? You get everything that you've negotiated for at the closing, then maybe there's a transition period or something along those lines, but it's yours, right? It's one, then it's the other. On the JV side, it's kind of a continuum where things move into the JV. If it's structured as a JV company, you establish the relationship, but there always is eventually going to be some sort of exit associated with that. And that exit can look like a variety of different things, which we'll dive into later. The nature of that is one element that should be thought about in the context of valuing the IP. The other aspect of that is that the parties that you're dealing with and negotiating with are still there. And they're still going to be your counterparties, perhaps indirectly as other members. They're still going to have probably other IP that's associated with this. And so there's a constant interplay between the co-venturers and the joint venture, the co-venturers and each other, and the group individually and collectively vis-a-vis third parties. All of these things can also have their own separate IP relationships. And so as you're trying to think through value, you kind of have to think through triangulating all the way around. Is the license from this party, co-venture A, down to the joint venture, what's the value look like there? If they are, for example, making that license and it's a non-exclusive license arrangement, they're licensing to third parties. Okay, how does that dynamic affect what you're doing? How does it affect your market, et cetera? And so having that dynamic conversation with your IP expert may yield a different valuation result than just simply saying, yeah, we're thinking about contributing some IP or entering into a license agreement with the JV. Yeah, what do you think it's worth, right? Very different conversation.
Thank you, Steve. So much of the time, well, first off, we should talk about, well, what is material to the transaction, or, what is important. And I always say, IP is just like any other investment, and you should be focused on profitability. Near term, if it's super speculative, you really got to reduce what you're assigning as value. The good thing about IP is most of the time we can do so much due diligence in advance. So before you're really running down the path with a proposed co-venture, another joint, for a joint venture, you can really see a lot of what they've done. You can get a sense of how sophisticated they are, how valuable their intellectual property is, whether you should be, whether they're the right partner or someone else is, or whether there's really not enough upside. Although most of the time we can find a way for you to get the upside, with proper selection and proper strategy. But some ways to determine if the IP is actually valuable. Number one, do they own it? Title issues are very common. We can generally push through those as long as there's still the entities aren't defunct, that people can still sign on organizations' behalf. So most of the time, title issues are not going to be a problem. So don't make too much out of that. And understand that sloppiness, even for sophisticated organizations, is common with respect to this. Again, kind of a failure to communicate with intellectual property counsel and things like that. So don't make too much of that. Most of the time, that's easy. Detective work, and this, it varies by the transaction, but you want someone with enough experience who's seen enough of these things to be able to follow the leads. So if they say, well, okay, we're thinking about doing a joint venture with this company, and they say that they've got patents that lock this up, that no one can do anything like this. That's almost never true. Okay, I mean, think about it. Apple's got a great patent portfolio, but there are a lot of phones out there, and some of you are probably not carrying Apple phones. You're carrying competitive phones. So most of the time, we completely own this market is wrong. So start to be a little skeptical there, but you follow through and you start to look at the range of other options out there. And see what you can do. You can also look at the protection once the patents are issued, they're public. Most patent applications are published around the world 18 months after the first filing. Sometimes we chain things together, then they publish more quickly. So we can see a lot of what has taken place. So we're doing our detective work. We're working with our client to figure out what they think the upside is. Again, commercially focused, where's the profit, where's the real upside, and it's not about this is neat, it's how much money are we going to make, right? I mean, I think unless you're in an organization where that's not the goal, which I think most of your organizations want to make money, or avoid losing money, because some are nonprofits, and that due diligence helps you there too. So when we talk about designing around protection and such, oftentimes with respect to patents, early enough in the process, we can generally find a client a way to do what they want to do. So we take a look at the protection and then figure out what the true value is. How much exclusivity do we really have? And then we see whether there's broad patent coverage, even broad patent coverage. Oftentimes, I have a rather pessimistic view of the competence of most U.S. Patent Counsel, for example. We can generally find holes.
That skepticism is fairly well earned too. So.
We've proven it time and time again, and we'll get to how we communicate this, because we're still in is this a good joint venture partner? And if so, how much value is there really there? But if you can get to the nice to have type of that this is a nice to have transaction, it's not a must have, and I can go into a meeting with senior executives of each organization and their patent counsel or intellectual property counsel and say, we don't need to do this deal. We like you a lot. We think it could work well, but understand that we can do this, 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 and this without having any problem whatsoever. And I'll say, I have already told them I'll provide opinions to that effect that tell them why they have the legal right to compete directly with you without doing this deal. That changes the dynamics. And of course, you can always say, well, oh, it's that patent attorney or that intellectual property attorney, you don't hate them. But, and whether or not it's a pure, cash, discount for contributions or some other concessions, at least you're starting to arrive at a fair value for, the contributions.
Right, and just to really drive that point home, it's sort of interesting to see in the context of a negotiation where somebody starts off with, we've got this locked up, we completely own exclusivity to this, and then all of a sudden you present to them the fact that, that's not exactly true. Very much changes the negotiation dynamics, not only on the price and the valuation aspect, but also will touch upon a lot of other different very important elements in the joint venture agreement itself, which we will also hit upon a little bit later. And those can really unlock a lot of value for your organization as well.
And you don't come out saying, telling them that their babies are ugly from the start, right? I mean, I don't think that's the best way to do things. So you start out amicable, and you can, if they're patents you're talking about, you can say, well, there was a lot of work done before patent counsel, and there was a limit to how much protection you could get, and things like that. But I've done that, and then heard, well, this is the blockbuster patent. I'm like, all right, this is going to be difficult, and here we go. I'm going to say, well, actually not, because we can do this, 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 and this. It's manufacturable, quite inexpensively, as it turns out. So that is not really giving you the coverage that you think. And if you've got their executives in that discussion as well, that's helpful, because then they can see that back and forth. That there's really not. I'm not hearing any good arguments from my intellectual property counsel as to why my patent portfolio or the rest of my intellectual property portfolio is as valuable as we thought. If you can get through that as amicably as possible, then you reset those expectations, which is really nice. One thing to bear in mind as well with low value intellectual property protection is that you've got less operating space, essentially. So you're more likely to have litigation. If you've got a really strong patent portfolio, a lot of times, and this is our goal, we try to make it so that no competitor wants to sue our clients, because it would be, the old mutually assured destruction, or at least, really expensive and difficult. Also, we try to have cross-licensing fodder as well. But if you're going in and you don't have much of a position, then you have to start to think, how am I going to achieve the value in this partnership, in this collaboration, joint venture, or whatever form it may take, in order to make it worthwhile to go forward. And please ask questions, as they come up. Feel free to interrupt us, because that's more fun. And so feel free to interrupt at any time. As we say, negotiate the issues preferably with the executives so they can hear the back and forth and understand. It's not, if you do it on a call just with counsel, then the opposing IP counsel may say, oh, they're a bunch of jerks, and they think that you're all idiots and such. No. We're just talking about objective value, and we're happy to hear your side of it. And let's come to if we don't come into a complete agreement, at least people understand where we're coming from with respect to our view of the value of the contribution. So we also assess the sophistication level, and also, frankly, veracity during the negotiations. We listen for off-the-cuff comments. I actually, they never hired me to analyze competitors' best. That was actually, opposing counsel actually said that with the executives there. I look at like, whew, okay, so boy, we have a disconnect here. This is probably not going to be a long-standing client relationship going forward after you just threw them under the bus like that. But also, the fact that it was never addressed means that patent counsel, in this case, hadn't raised it, nor was the client sophisticated enough to do that. So, okay, so now we know we've got a lower sophistication level, and they probably haven't done their due diligence. They haven't been looking at the marketplace and their competitive threats, including intellectual property threats. So it's probably going to drive more due diligence. So we have to understand, the risk is higher. It's always higher with those organizations, okay? And then, okay.
If you don't mind my jumping
No,
in,
go for it.
that can also clue you into some additional negotiating dynamics as it relates to transfers and exits. So, for example, if you assess that the sophistication of your counterparty or your co-venturer is relatively low, or that they perhaps have taken certain shortcuts, depending on what you're looking to achieve in connection with the partnership, right, in connection with the joint venture, it might be something where your co-venturer delivers less than what you're expecting. And so the ability to basically move on or to take control of the joint venture might become key if they really aren't delivering on their end of the bargain. So that's something where sometimes you enter into a JV and you know that the other party is going to deliver, and it's going to be, at least in that aspect, a marriage, a match made in heaven. But if you have on the front end, if it's still a good enough deal to give it a try, think about your exit options as you're entering into it, because there's a good chance that they may not be able to perform.
And that's in stark contrast, oftentimes, to an acquisition. You can look at what they've done and you can say, we'll bring some talent in and we'll bring a sophisticated approach, and we'll do what they should have done and maybe undo some of the things that they did. But here, it's like a bad marriage. And yes, I'm in a really good marriage now, but I had a bad marriage. You really don't want to enter into that in your work if there's not a compelling reason to do so. And again, is this the best partner? And we're going to talk a little bit about deal dynamics as well, and business development executives and how that can work, too. So we'll address that in more detail. But having a good proactive approach and being realistic about what the other side is going to bring to the table is extremely helpful. Of course, deceptive actions typically drive more due diligence, and you can pick that up in a number of different ways. Sometimes people are kind of lazy about populating data rooms and things like that, and sometimes you're doing your own due diligence, you find stuff that are problems, tax lanes, licenses out that are public that they're not scheduling, and that impact the core intellectual property and things like that. And it doesn't take, at one or two of those, you really have to start, and then of course you communicate with the client. This is starting to get concerning, and it helps to have a lot of experience with these types of transactions. I say, we're getting out, this is an outlier, it's becoming an outlier, because most of the time, the organizations would not be doing this. And so it may be lack of sophistication, but now it's looking like something more, and that's a huge red flag.
It's a huge red flag, but it's not necessarily as well something that you beat the other side over the head with. Oftentimes you're just sort of filing it away. And so it kind of goes back to the looking at all the levers approach. Is it something that you can necessarily hit directly in connection with evaluation? Oftentimes that's not well received, but perhaps there's a small ding there. But then there may be other aspects of what you're looking to do where you use a little bit of this, if you will, I'll call it deal leverage, to push in other areas. So not simply maybe just the transfer dynamics, but there may be elements on control. So whether you're the one in control or they're in control, or you've got for example, a material issues list, right? This may be something that allows you to address some of your potential downside concerns through a material issues list. So some of these items that may be concerning may be things where you're able to basically grab the wheel or take the wheel if it looks like they actually haven't delivered on something, or something that you were expecting them to deliver doesn't materialize.
So then based on everything that we talked about, then you determine whether or not it looks like it will be as profitable of a venture as anticipated. If not, then, some type of concessions are, typically appropriate. So, there are risks associated with any, combination like this, of course. Vary widely, and they vary widely by technology. Some of us, we watch every intellectual property litigation and contested proceeding to see what's happening out there by technology and by oftentimes by company as well. So we can factor that in. We do communicate that to our clients as well. And you need that. Going back for just a moment, you need that. You need to really understand what the goal is. What the commercial goals are. What is the upside, so you can focus your due diligence appropriately, know what's important and know what's not, be hyper-focused. Look, if you've got a bad actor on the other side, it's not going to be directly related to the JV, well, that's still relevant, but you're not going to have to dig into it like all the technology and, for example, intellectual property that's directly associated with the JV. But please do keep that in mind. You need that open lines of communication and to understand the commercial goals so that you can tailor your due diligence and your approach appropriately. So, as you form a larger organization, oftentimes that will be more of a market threat. And the fact that a smaller organization or the two smaller organizations were not a threat does not mean that you're not going to have litigation post-JV, post whatever the transaction may be. So bear in mind that, some clearance work, some people call it freedom to operate work, looking at potential threats, whatever they may be, patent, trademark, copyright less commonly, but have a strategic and proactive approach with respect to that. You can generally manage those risks well. Focus on the important deliverables. You give the value assessment, in a candid fashion, not jargon-filled. You do compare the risk profile, with respect to what the client has typically done. If you've got a client who has typically done pure mechanical, fairly, old technology, as their primary business, and they're going to go into electronic controlled machines, networked machines, things like that. The risk associated with that, particularly with respect to patents, is completely and totally different. Doesn't mean that it's not a tremendous opportunity, exciting, you can drive a lot of profitability, exactly where the client should be going. But the C-suite and the board need to know that you're entering a different world, to a large extent here, and understand that, they're going to be, the polite term is non-practicing entities, patent enforcement companies and things like that you've never heard from that you may now. So you're factoring in the landscape, the risk assessment, you should definitely bring that to your client's attention as well. As I say, it's typically not a deal killer, but make sure that everyone does understand that this is an enhanced risk going along with the enhanced upside as well. And then know as well that if it looks like there's still a lot of value, that a lot of times we can undo things that have been done already, particularly if they're pending applications, pending trademark, really more patent. If you just allow a patent to issue without, and in these transactions, oftentimes we'll say to our partner, don't let anything issue, particularly if they're not sophisticated, don't let anything issue without having what we call a continuing application. Have something pending so that we can come in and we can help you to add more value to the portfolio, and we do that cooperatively. So a lot of times when we spot issues, potential problems, but oftentimes we come in with the solution as well. It's part of the value that the client can confer to the other side as well. So it doesn't mean that, there are problems and so we're going to abandon. Most of the time you get the deal done, it's just there are different concessions and such, different corrective approaches that could be useful as well. Okay. All right. One of my favorites. So do you have, yes, here we go. So I'm not going to ask the question because I don't want you to have to raise your hand. But it is not uncommon to have a business development executive running the deal, or leading the deal, and they are oftentimes compensated and reviewed based on how many transactions they brought to the company and they closed. And they have complete, how do I put it, deniability with respect to what ultimately happens. So they'll say, the fact that it's completely unprofitable was a failure of execution of all these people. I brought a great deal to the table and I closed it, and these people should be getting tagged instead of me because I'm great, I brought this great deal, and they just didn't execute very well on it. You have to have your input going to whoever's got to live with the deal. And sometimes it's the CFO, sometimes it's the president of a business unit. You have to get there so that your input is not going to the business development executive, and the business development says, yeah, they're a bunch of naysayers and such, but this is all looking really good. Get to and you also get better if you're talking to people who are living with, who are going to have to live with this. You'll get more input with respect to what they view as the upside and what they see as the impediments to great profitability and things like that. That's invaluable with respect to your due diligence and really ascertaining overall how this is going to play out.
That's a great point. And one of the differentiators on the joint venture side from the M&A side is that oftentimes you're going to need to populate that joint venture entity with a management team. And so the management team that's going to be, if you will, operating or overseeing that entity, they're going to have a real vested interest in what this is going to look like on a go-forward basis. It's their careers, right? It's the success of that entity that's going to determine, perhaps their future advancement in the company, et cetera. So talk with them for sure and get their take on what they view as potential related issues as well, just purely from an execution perspective at the very least, because their input's going to be valuable. And so obviously the team approach, sometimes if you have somebody in a position who's running a deal who maybe falls into the scenario that Jerry described, the team approach often can be helpful in trying to get to higher level decision makers that might be able to move around it. There's also, I think, an important dynamic that important benefit that outside counsel can provide, which is probably true in connection with most of the deals that you all run, right? But the question is whether certain potentially difficult conversations are better delivered by you all as in-house counsel to those folks, or if it's better coming from outside counsel. I think sometimes some of the scenarios we commonly see where the outside counsel approach is best is when, if you will, you need air cover, right? Where you need somebody to say, like, look, we've done 10,000 of these deals and this is the way that we see this particular scenario usually handled. Or it's something where, if you need somebody to play bad cop, right, we can play bad cop, and you throw us under the bus a little bit. Hopefully we don't get completely destroyed by it. But if you need it, to a certain degree, that's what we're there for. Because at the end of the day, we all represent the same client, right? Which is we need to ensure that the company is going to be in a good situation going forward. We also go ahead, please.
And you can add value, in that way. Particularly, there are times when you have a new in-house colleague, and you have a long-term relationship with, I have a CTO, I have a long-term relationship. You're a new chief IP counsel, and there were some difficult things that had to be said, and basically the CTO was becoming frustrated, and if you've got a longer-term relationship, sometimes you can kind of jump in and provide cover, and say, here's some things that you've been so busy with these other things. Here are some issues that we're going to brief you on, and this is really where where they're going, and it is very reasonable what they're saying. You can provide a lot of help, and that's just a good thing to do. Like he said as well, oftentimes it's easier for us to say, we see so many deals. You may see 10 per year. We will see 100 or more each. So, end of the day, we know what is customary here, particularly with business development executives, those folks who have some have fallen in love with the deal. I mean, we work with some business development executives who are fantastic, sophisticated, don't fall in love with the deal, coachable, they're essentially perfect, but then we've got some others, it's going to be, it's a negotiation with them with respect to, why you need to take certain steps and, why the deal's not perfect. And sometimes, and my view is always, you let your in-house friend make the call, right? Do you want me to run with that, or do you want to do it? And then, a good team approach.
It's probably a good time to mention this as well. Just thinking through, I'm sure, we've all worked with a variety of different outside counsel, and, there are so many different flavors that you come across. And quite frankly, our job a lot of the time is to be multiple different flavors, depending on even potentially who we're talking with in connection with the deal, right? We can be chameleons as necessary. But you will come across some groups that have a more aggressive style or domineering style. And that's not to say that being aggressive is a bad thing in certain scenarios, but sometimes you'll see groups that will say something to the effect of, well, this is the market, full stop, and this is always the way that we do it, and will essentially try to pound your deal into whatever their gestalt is, right, whatever their model is. And something that you and I have talked a lot about is that, we'll dive a little deeper into this later, but there's such a multiplicity of different types of joint ventures, different purposes, different fact patterns, different parties that are in a variety of different industries, parties that are competitors or potential competitors or not competitors at all. And when you take a look at all these various variables and you get the answers, right, to all these various inputs, there is no market, right? There may be general ways that these things are typically dealt with on an issue-by-issue basis. And I would say, the fairway, there is a fairway, but it tends to be pretty wide. But to say that this one way is the way that things are done, and to tell other people in the context of a deal, you have no idea what you're talking about, we never see it this way. You've probably never seen this exact deal before. So it's when you're doing these, I think certainly more than an M&A deal, they're very, very nuanced. And if you're really looking to drive value post-closing for the organization, it's important to understand that these really are bespoke arrangements, and putting the time in on the front end to get those things dialed in correctly really will make things easier on the back end. And even if things go bumpy, at least you've got escape hatches in connection with it, or different ways to maybe flip control or things of that nature.
And a lot of these relationships are ultimately like marriages. And so you always want, in my view, you start out amicable every single time. I mean, if you need to get tougher, you can be tougher, tough as you need to go, right? But, I think a great deal lawyer, including a great IP deal lawyer, is really a lot like a great trial lawyer. You can read the situation, adjust as appropriate. It's not one size fits all. And generally, you don't go straight to pounding on the other people, the other side, because, and it's even more important here, where you really want the two organizations to have a great relationship going forward. So, multi-dimensional approach, virtually always the best way to do things. One of the things we haven't talked about yet is, if your client has a dominant intellectual property portfolio, for example, then, how will things be structured? Think about that. You're bringing more value with respect to that. You're probably bringing a lot more expertise with respect to that as it evolves. It's probably going to continue exactly that same way. So you're going to bake in certain things. You're probably going to be more likely to be the ones enforcing. You're the ones who are going to be leading the discussion. You're going to have a lot more say with respect to the strategy of the intellectual property portfolio going forward. That's typically, and conversely, you may look at that and say, okay, they're highly expert, they're doing a great job, and that's part of the value they're bringing to the table. So again, it is very custom, with respect to these, it's a give and take, and you look at the situation and you determine what's appropriate.
And back to that double-edged sword element. So you could be doing a deal that's a strategic access play, access in a new market, and you've got to figure out those relationship dynamics with the party that, let's say, is the local party in that jurisdiction. But IP is going to play an important aspect of that process, right? The nice thing about setting up your joint venture, especially through using alternative entities, it's not just what's your ownership percentage? Well, ownership percentage could be kind of an amorphous concept as well, because your distribution waterfall can be multi-tiered and complex. It's not just who's on the board. Your board can be as many different boards or have as many different committees as you want. You can assign the responsibility to a variety of different actors, to new groups. There doesn't have to be overlap. There can be overlap. The process in connection with each can be different. Basically, the sky is the limit in terms of your creativity to be able to address issues and problem solve. But of course, you have to counterbalance that with whatever the legal spend looks like in connection with that. But the point is that you can address these things, you can work through them. The key to it is really just spotting the issues on the front end to be able to have those productive, collaborative conversations. All right, so how to pair up, how to avoid squandering value when doing it. So I'll just kind of quickly hit some of these. You all can look at the list. When you're thinking about all the various things that will go into the joint venture, this is really the time to do that issue spotting, to really think about the various different ways that the intellectual property, for example, is going to be used, what the dynamics of it all, what you're looking to accomplish in terms of the purpose, what you're going to need in the joint venture, what the other parties are going to need to retain and to utilize as well. Mentioned it before, what if they're retaining certain rights associated with the intellectual property, the co-ventures are retaining certain rights but allowing the joint venture to use it, how are they going to be using it? How could that potentially affect your investment into the joint venture? On the flip side, if they're contributing the IP in but maybe licensing it back out, what are the dynamics associated with that? So definitely take a look at the inputs, think about the outputs in connection with it, and then that's the time to kind of sit down and have a fairly deep conversation to figure out, okay, strategically as it relates to our IP, what do we want to accomplish here? What do we think the risk factors are? And then from there, it's off to the races to develop strategies on how to address them. So the upshot of all of these inputs and these outputs is there are a lot of key issues to be evaluated. And as I mentioned before, the answers to each of those issues have significant repercussions. And so, for example, just focusing on like the JV purpose issue, if it's a scope play that's focused on accessing the foreign market, that's going to look very, very different than a JV that's focused on, say, co-developing certain specific technological capabilities within an industry. And that's just simply an access deal. It's a scope deal is very different than a risk mitigation deal, is very different than a scale deal. And so right at the outset, the purpose is going to drive very, very different joint ventures with very, very different relationship dynamics right at the outset. And that's just the purpose. So recognizing that on the front end is oftentimes key to sort of opening up productive conversations with co-venturers and also opening up productive conversations with the board, with the C-suite, et cetera. Because sometimes folks will approach it with a very narrow mindset and say, oh, we've done 1,000 of these and we know exactly what we'd like to see in a JV. It's great that they have that experience, but one JV typically doesn't look like the next. This one is something that a lot of folks don't think of, but it is very important not only to document and to understand precisely what's going into the JV, but also what's not going into it, right? So the positive and the negative. You don't want to license, say, A, B, and C to the joint venture and then stay silent with respect to D, E, and F when D, E, and F all relate to C. Because if C, along with A and B, are going in and D, E, and F aren't addressed at all, you might intuit, it might be implied that D, E, and F are also supposed to be accessible by the JV. So document what's going in, but also document, importantly, what's not going in. And of course, there are two main ways of doing that. You can either have specific inclusions with a broad exclusion or specific exclusions with a broad inclusion.
Okay. So we've already talked quite a bit about the valuation of the contributions, of the, we can assign the IP in. We may license, if we assign it in, we may license back out, but for what purpose? You really want to take a look at, is there going to be a competitive type of operation going on outside of the joint venture? You have to be cautious about that, of course. What about improvements? If improvements occur or generated with respect to the technology, does it all go in? Are improvements licensed back? What's the pricing associated with that? So just think about, do either of the entities need to have ongoing access outside the joint venture, and if so, what is appropriate?
And just to add in on that, it's really kind of, if you will, multi-level chess, right? Where if you've contributed the IP in and the IP gets improved and you've got a corresponding license back out, does the improvement automatically get licensed back out, or is that a new negotiation? Similarly, if you don't contribute the IP but you license it down and there's an improvement up top, does that automatically get built into the license down to the JV? So every single time you're looking at these, there are just multiple dynamics to sort of keep in mind, plates you have to spin.
Okay, and then with respect to licenses, a lot of you already know a lot of the licensing basics. They apply here as well. I see that we're rolling along on time, so I'll just hit them very. I think this is pretty self-explanatory. But you can of course cut things up or parse them out in a number of different ways. And you can have different royalty structures and things like that as well. The ownership of the improvements, you do need to think about that. Is everything going into the JV? Is it is one who has dominant protection, and then their licensing? You can be very creative. Just think about, keep an eye, or keep thinking about not only the formation, but the running the JV and then the exit as well.
And I think in particular, like, for example, in the field of use restrictions, are there geographic limitations, time limitations, use limitations? For example, production of a particular product or delivery of a particular service, or is it used only in a particular industry? Each of those dynamics can be important in terms of what you need to address and what you perhaps don't need to address, depending on which side of the table you're on and how you think the JV and its IP is going to play out in your favor or perhaps not in your favor.
And then enforcement, you may need to enforce, is it going to be the JV, or, if things have been assigned in, of course, whoever's got the dominant intellectual property protection that's relevant, more likely than not, will be, at least have the first option to enforce. You can have cascading rights, of course, with respect to that, much like your other types of agreements. But it's good, again, to anticipate those issues. And one thing to note, with respect to intellectual property in particular, before it has become extremely valuable in the context of the JV is the best time to reach agreement on these issues. It's much more difficult when tremendous value has been established and everyone understands just how much they're giving up in the agreement. So do it earlier, be proactive. It's so much more straightforward and leads to better results.
And there's another reason for doing it as well. In addition to not, allowing, if you will, the JV to prove out the value of something and then having to negotiate on the back end after the value has already been proven or disproven, you've also got the leverage in the beginning of the negotiations as to whether or not you're going to enter into the JV at all, right? So you have each side has better leverage to be able to push and to try to strike the right deal at that point in time without having another side that may be weaker after the deal gets struck have to take on effectively that deal risk for the benefit of the other party. So breaking up, and how do you not lose your shirt in connection with that? So one of the things to think about are the consequences of termination. Just because you contributed the IP in or license, it doesn't necessarily mean that you get it back. You have to negotiate specifically for these things. You have to think about the type of termination. Is it going to be a termination by dissolution followed by a liquidation? Is it going to be a termination by sale? Is it going to be a sale to a third party? Is it going to be in the context of a drag or a tag? Is it going to be done through a push-pull buy-sell agreement? Is it going to be a put-call arrangement, or maybe one of the parties is going to exit but other co-venturers stay in? All of these things are important to think through as it relates to what you're bringing to the table and what you're expecting to get out of it. And so if you don't think through these things on the front end, it's probably starting to sound a little bit like a broken record now, you can really lose your shirt on the deal, right? You can end up not being able to pull back things that you needed, or after the entity sold, you may not continue to have access to it. A simple example of this is that you perhaps contribute IP down to the joint venture, and then you're getting a corresponding royalty-free perpetual license back out. But it may not make sense, and it may, for example, chill potential acquisitions, or it may hurt your deal value to have that continuing out there. So maybe a different way to cut it would be to allow the joint venture under certain sales scenarios to be able to be sold and to terminate that royalty-free perpetual arrangement, but then to in place of that as a replacement to then have a certain term license arrangement that may or may not have certain sweetheart dynamics and pricing to it, like so that you get to retain it for a certain period of time and then maybe transition out of it. That way you can still sort of maximize the value on the sale of the JV without completely crippling your organization as it relates to that specific IP product. So let's see. Talked about those. Want to make sure we're hitting some of the high points here. So let's talk about key traps for the unwary, and then maybe one slide after that. So I'll let you take it.
Sounds good. So a lot of businesses have IP, whether or not it's registered or not. You've got copyrights, you got common law trademarks oftentimes. So, look for those, whether or not there are filings. A lot of times, people say, well, we're just going to share. Sharing is great. So, we're going to jointly develop things, and everything's going to be great.
Co-ownership.
Co-ownership. Joint development leads to co-ownership. What does that mean? You think, well, you're going to treat each other fairly under the law. Well, U.S. law, with respect to most intellectual property, let's talk about patents for a moment, but most are like this. And it places a premium upon having a written agreement. And having thought about this stuff is that when you jointly develop, you jointly own. And when you jointly own, you can do whatever you want with it, make as much profit as you want, and not give your co-venture or partner a dime. So that's counterintuitive to what we would typically think. So, the way around that, of course, is to have a good agreement with respect to that. One thing that we also do as well is, even when you've got a joint development, you've reached agreement and such, well, there's no reason to make things joint if you don't have to. And if you're strategic and proactive, what my clients will typically do is, we'll brainstorm ahead of time. So when they go to the joint development brainstorming session, they've already documented a lot of improvements. And they've gotten them to us, to people, more credible than, a patent lawyer, right? Who could testify that, this disclosure came in with all these innovations. That leads to the dominant intellectual property portfolio within the venture, ultimately, which gives you more flexibility as you go forward. So, even once you reached agreement, still being proactive and thinking about these issues, doing your innovation separately as appropriate. A lot of that stuff comes out. A lot of the value is developed in those types of processes if you just take a very short period of time to do that. And then, lastly, we want to say that if you contribute in fact, you said it, if you contribute the IP in, you may not get it back anyway.
So, recurring theme: there's no time like the present, right? These things do tend to be front-loaded. There's more work to be done on the front end, but quite frankly, that's where you can add and preserve a lot of value. Questions should be asked, due diligence should be performed. A couple of things. One, protect against another party test driving what you're contributing, test driving your IP, and then perhaps having the ability to have a sort of a free look at it to get it later. But on the flip side, if you're probably more likely to be the acquirer in connection with it, it's a great time to test drive the other person's IP, prove out the value, and to do so in a de-risk environment where you haven't fully committed, such as in an M&A transaction, where you can share some of the risk associated with proving it out. And so with that, it's one of my favorite quotes, but it rings true so often. For every complex problem, there is a solution that is simple, neat, and wrong. Sometimes things just can't be simplified, and from my perspective, it's important to just recognize it, accept it as what it is, and plow through it.
Any questions?
I think we're actually over time by quite a bit, so we got to figure out the next one. But appreciate your speech today, and thanks for engaging.
Thank you.
Yeah, thanks for having us.
And we'll answer questions outside as appropriate.
Thank you.